the Trump administration is they turned off money going to nonprofits and contractors on foreign aid, people that were working with the organization USAID, the agency that the Trump administration was trying to shut down. And what the Supreme Court, what Trump wanted to do is he wanted a green light from the Supreme Court to keep that money shut off. It's being litigated at the trial level courts far below the Supreme Court.
Okay, so picture this moment in American history where 9 people wearing black robes walked into a grand chamber in Washington, D.C. and delivered a decision that fundamentally rewrote how power works in the United States, at least when it comes to trade and executive authority. This was not some made-up drama for clicks or a sensational YouTube thumbnail splashed with flashing red and blue graphics designed to trigger emotions. This was the real version, grounded in law, precedent, and the kind of constitutional reckoning that happens only a few times in a generation. It was February of 2026 when the Supreme Court issued a 6-3 ruling, with Chief Justice John Roberts himself taking the extraordinary step of writing the majority opinion. In that opinion, the court firmly rejected former President Donald Trump's bold assertion that he possessed near unlimited power to slap sweeping tariffs across the entire global economy simply by relying on his own interpretation of a decades-old 1977 statute. The justices did not merely rule against one specific policy or one set of tariffs. They dismantled the entire legal foundation that the administration had constructed its aggressive trade strategy upon. They declared his expansive reading of the law far too broad, unsupported by the text, and inconsistent with the division of powers laid out in the Constitution. The message was unmistakable, delivered in clear, measured judicial language, no. And the reaction that unfolded in the hours and days afterward was every bit as dramatic as you might imagine, but it was not fiction. It played out in real time across social media platforms, in front of cameras, and even in leaked private conversations that spread through Washington like wildfire within hours. Here was a president who had spent more than a decade convinced that he essentially owned the Supreme Court, only to wake up facing a direct rebuke from justices he had personally selected and celebrated. It was the kind of moment that left political observers shaking their heads, asking whether anyone could truly believe the depth of the fallout. But before we dive deeper into all the layers of what this decision truly means for the country, its economy, its legal system, and its future governance, let us pause for a moment of honesty. In today's media landscape, trust in mainstream outlets has eroded significantly for millions of Americans who feel that stories are filtered, spun, or shaped to fit certain narratives. That is precisely why platforms and channels like this one exist, to deliver real stories with genuine context, free from corporate influence or partisan blinders. If staying informed without the usual noise matters to you, consider joining the free newsletter where the most important updates arrive directly in your inbox each day. No fluff, just substance. And if you feel moved to support independent voices committed to truth-seeking, becoming part of that community makes a real difference. With that said, let us return to the heart of this pivotal ruling and unpack everything it represents. Just 4 days after the decision landed, President Trump addressed the nation and supporters in his characteristic style, describing it as a very unfortunate ruling from the United States Supreme Court. He acknowledged the disappointment but quickly pivoted to optimism, noting that almost all countries and major corporations involved wanted to preserve the existing trade deals they had already negotiated. He pointed out that the alternative, facing even tougher terms under his renewed negotiating leverage, would be far worse for them. Therefore, he argued they would continue operating along the same successful pathways established before the court's intervention. Despite the setback, he emphasized that the money-saving measures, the protections for American industries, and the peace deals he had helped broker using the credible threat of tariffs would largely remain intact. These outcomes, he insisted, could now be supported through fully vetted alternative legal authorities that had been tested and approved, ensuring continuity without disruption to the broader agenda of putting America first in global commerce.
To understand why this court decision carries such lasting weight, we need to examine precisely what the justices actually did. At its core, the case centered on the International Emergency Economic Powers Act, often abbreviated as IEEPA, a law passed back in 1977. This statute was designed to equip the president with certain economic tools during times of genuine, unusual, and extraordinary threats originating from abroad. Over the course of his presidency, Trump and his legal team had leaned heavily on this act to justify an ambitious array of trade actions that reshaped global supply chains. These included a blanket 10% tariff applied across the board on imports from virtually everywhere, 25% tariffs specifically targeting Canada and Mexico, and dramatically escalated duties on Chinese goods that climbed as high as 145% in some categories.
According to the administration's lawyers, all of these measures were authorized under IEEPA because they tied into declared emergencies involving national security concerns, the flow of drugs across borders, persistent trade deficits, and whatever other justification seemed relevant on any given day. The Supreme Court, in its 6-3 decision, delivered a resounding rejection of that approach. The justices clarified that IEEPA allows the president to regulate certain economic transactions in emergencies, but it does not grant authority to impose taxes in the form of tariffs. Tariffs, after all, are taxes, and the Constitution could not be clearer on this point. Article 1, Section 8 places the power to lay and collect taxes squarely with Congress. It is right there at the beginning of the document, the very first branch of government described, the first major powers enumerated. This is not some obscure footnote or implied authority buried in later amendments. It is foundational. When a president attempts to bypass that clear allocation of power by stretching an emergency statute never intended for broad taxation, the court has both the duty and the authority to intervene. That is exactly what happened here, with Chief Justice Roberts leading the majority in a decision that spoke directly to the limits of executive creativity in interpreting statutes. The public meltdown that followed was predictable to those who have followed Trump's relationship with institutions, yet still striking in its intensity. Headlines across platforms screamed about total chaos because the president's response aligned perfectly with long-established patterns. On social media, he expressed outrage, labeling the ruling wrong on multiple levels. He directed criticism toward the justices, questioning their reasoning and at times their qualifications. He spoke of weak decisions, disloyal actors within the system, and betrayals that cut deep. What reportedly stung the most was the fact that two of the justices who joined the majority against his position were individuals he had personally nominated and championed during his first term: Neil Gorsuch and Amy Coney Barrett. These were the justices he had highlighted in rallies, defended against intense opposition during confirmation battles, and pointed to as crowning achievements of his influence over the judiciary. On that Friday morning when the opinion dropped, they reviewed his signature economic policy and concluded that the Constitution simply did not permit it. For a leader who viewed the court as an extension of his own will, this was more than a policy loss. It shattered the comforting illusion of total ownership over the institution he had helped shape. The ruling carried implications far beyond the immediate invalidation of tariffs. A 6-3 decision authored by the Chief Justice establishes powerful precedent. It becomes the kind of legal principle that lower courts, future administrations, and legal scholars will cite for years, possibly decades. The core idea the court reinforced is straightforward yet profound. Presidents cannot unilaterally invent expansive new authorities simply by declaring something an emergency. True emergencies must meet definable criteria, and the statutes invoked must actually contain the powers being exercised. If Congress intends to delegate broad new powers, it must do so with clear, explicit language rather than vague phrasing that invites creative readings and executive overreach. This principle extends well past tariffs. It touches every instance where any president, regardless of party, attempts to expand authority through emergency declarations or strained interpretations of old laws. And Trump had relied on this strategy repeatedly throughout his time in office. Let us take a step back and explore the deeper significance, because the tariff case, while headline-grabbing, represents only the most visible manifestation of a broader evolution underway at the Supreme Court over the preceding year. Many casual observers remain unaware of just how transformative these developments could prove for governance in the United States. The legal foundation of the ruling rested heavily on the major questions doctrine, a principle that might sound academic at first but carries immense practical weight. In essence, it holds that when Congress seeks to confer enormous new powers upon the executive branch or administrative agencies, it must speak clearly and unambiguously in the statutory text. Vague implications, creative reinterpretations of statutes originally written for different purposes, or stretched readings of old laws will not suffice when the stakes involve economy-wide changes or fundamental shifts in authority. Because IEPA lacked any explicit authorization for the president to impose tariffs as taxes, the administration could not bootstrap that power into existence through clever lawyering. This doctrine has become especially relevant given the administration's broader philosophy of executive power, which often involved identifying older statutes, reading them expansively, and deploying them for objectives their original drafters likely never contemplated. IEEPA served as a prime example, but others abounded. Section 232 of the Trade Expansion Act, provisions within the Immigration and Nationality Act, even the Alien Enemies Act dating back to 1798. Each had been tested at the edges, pushed toward limits that tested constitutional boundaries. The major questions doctrine functions as the court's clear instruction that such stretching has its limits. If massive new authority is desired, Congress must provide it explicitly. Otherwise, the executive cannot simply declare it into being. This stance promises to influence countless future legal challenges. Anytime the administration reaches for an obscure or ambiguously worded statute to support sweeping policy changes, opponents will invoke this precedent. Judges will scrutinize whether the major questions threshold has been met. The result is likely to be more frequent injunctions, narrower interpretations of executive discretion, and a general tightening of the reins on unilateral action. This particular ruling did not emerge from nowhere. It fit into a sequence of Supreme Court actions over preceding months that demonstrated a willingness to check certain exercises of presidential power. In December 2025, for instance, the court turned down an emergency request from the administration seeking to federalize the Illinois National Guard, despite objections from the state's governor. By letting the lower court decision stand, the justices effectively required troops to respect state-level constraints rather than overriding them through federal command. Shortly before that, another emergency application involving immigration judges and policies aimed at limiting their independence met a similar fate. The court declined to intervene on the administration's side. Then came the February tariff decision, again 6-3, with the Chief Justice authoring the opinion. Viewed together, these cases suggested a pattern, not blanket opposition to the president, but a selective assertion of judicial boundaries where constitutional lines appeared crossed. At the same time, the court had issued rulings favoring the administration on other fronts. In Trump versus Casa, for example, the justices made it more difficult for lower courts to issue nationwide injunctions that could halt executive policies across the entire country. That decision represented a meaningful victory, allowing controversial initiatives to proceed while litigation continued, giving the administration breathing room to implement priorities before full judicial review. Legal analysts noted that such outcomes made it easier for any administration to advance agendas amid ongoing lawsuits. The picture, therefore, is nuanced rather than one-sided. The Supreme Court under this composition is not acting as a partisan antagonist or loyal ally. It is engaged in the careful work of drawing constitutional lines, sometimes constraining power, sometimes protecting it, always aiming to maintain balance. This recalibration process leaves the executive unable to predict automatic support or automatic opposition, forcing more careful navigation of legal and political realities. For a president who prefers bold, sweeping moves without restraint, this unpredictability creates frustration. Trump's personal response to adverse rulings reveals much about his worldview. He tends to interpret every judicial setback as a personal affront rather than a principled application of law. Justices who disagree become disloyal or misguided. Decisions limiting authority serve as evidence of systemic bias. The framework of constitutional principles operating independently of personal loyalty does not seem to register in the same way. Loyalty, in this perspective, demands consistent delivery of desired outcomes. When that does not occur, the response often involves public criticism, private rage, and attempts to question the legitimacy of the process. Reports following the tariff ruling described intense frustration expressed behind closed doors, accusations of betrayal aimed at his own appointees, and public statements on social media decrying rigged institutions.
These reactions add to a growing body of evidence about how certain views of executive power clash with traditional understandings of separated powers in a constitutional republic. A sustainable approach for any president requires respect for institutional boundaries even when inconvenient. Persistent challenges to that framework risk eroding public confidence and complicating governance over time. The country continues to observe these dynamics play out, learning what they mean for stability and the rule of law. Placing this decision in broader historical context illuminates its importance. The Supreme Court has checked executive overreach since the earliest days of the Republic, but the modern framework crystallized in the 1952 case of Youngstown Sheet and Tube Company versus Sawyer. During the Korean War, President Harry Truman sought to seize control of the nation's steel mills to avert a labor strike that he believed threatened the war effort. He acted via executive order without explicit congressional approval. The steel companies challenged the move, and the Supreme Court ruled against Truman by a 6-3 vote. The justices held that the president could not seize private property based solely on a broad claim of national emergency absent clear authorization from Congress. This precedent established that executive power operates within defined boundaries enforceable by the judiciary.
Justice Robert Jackson's concurring opinion provided a lasting analytical framework still cited today. Jackson outlined 3 zones of presidential authority: maximum power when acting with congressional support, a gray area when Congress remains silent, and minimum power when acting contrary to congressional will, where the president must rely solely on inherent constitutional authority. Courts have applied this framework in thousands of cases. The recent tariff ruling echoes Youngstown closely. Once again, a 6-3 decision rejected an attempt to use an older statute for purposes not clearly authorized by Congress. The major questions doctrine serves as a contemporary refinement of Jackson's categories, demanding explicit textual support for significant power claims. History rhymes across generations, reminding us that tensions between branches are built into the system by design. Breaking down the implications into clear components helps clarify the stakes. First, the tariff ruling transcends the specific policy area of trade. The legal principle it enshrines will apply whenever future attempts are made to derive massive authority from ambiguous statutes. The major questions doctrine now equips challengers with a potent tool in litigation against executive actions. Every judge reviewing such measures will weigh whether the statute speaks clearly enough. This shift promises more measured outcomes, additional legal defeats for overbroad claims, and a long-term recalibration of how administrations approach unilateral policymaking. Second, the nature of the public reaction offers insight into deeper attitudes toward power. When a leader who appointed multiple justices sees them rule against preferred policies and responds with accusations of betrayal, it reveals a transactional understanding of institutions rather than a principled one. Respect for separation of powers would involve accepting the outcome and pursuing lawful alternatives. Instead, the pattern involves attack and delegitimization, which carries risks for democratic norms. Observers note that these episodes appear to intensify over time, potentially leading to confrontations that test institutional resilience further. Third, the court's overall approach shows genuine recalibration rather than consistent favoritism or opposition. Some rulings expand executive flexibility by limiting universal injunctions, while others constrain it through stricter statutory interpretation. This case-by-case method creates uncertainty, but also reflects careful stewardship of constitutional boundaries. Fourth, the beneficiaries and those affected deserve attention. In the short term, small businesses burdened by high tariffs gain relief, potentially recovering costs and regaining predictability. Consumers may see prices stabilize or decline as supply chains adjust. Trading partners experience reduced uncertainty, fostering more stable economic relationships. The broader American economy, long subjected to volatility from rapid policy shifts, stands to benefit from restored predictability that supports investment and planning. Importers, exporters, logistics professionals, and entrepreneurs operating under previous chaos finally receive breathing room to focus on growth rather than constant adaptation to new duties. Over the longer horizon, the constitutional order itself gains strength. Each time the court enforces limits on executive authority, the principle that no individual or branch stands above the law receives reinforcement. Public perception of judicial independence benefits when even a conservative-leaning court checks a Republican president in accordance with legal requirements. This bolsters institutional trust across partisan lines and promotes long-term democratic health. Future presidents of any affiliation inherit clearer guardrails that protect against overreach while preserving legitimate tools for governance. Those who lose most directly include any leader tempted to invent powers through creative readings of statutes, as the precedent binds everyone equally. A future Democratic administration pursuing similar strategies would encounter the same doctrinal hurdles, which is precisely how neutral constitutional limits should function. Even strong supporters of current policies can recognize value in rules that constrain opponents as well, ensuring balance rather than perpetual escalation of executive claims. Looking ahead, several developments warrant close attention. The administration is unlikely to accept the outcome passively. Legal teams will explore alternative statutory bases such as Section 122 of the Trade Act or renewed emphasis on Section 232 of the Trade Expansion Act, among others. Each new approach will face judicial scrutiny under the major questions lens, with many likely encountering similar obstacles. The tariff strategy evolves rather than disappears. Meanwhile, additional major cases involving executive authority are progressing through the lower courts and